Welcome to Paradigm Shifts, new thinking about our changing times with your host, Harriette M. Steinberg, practicing matrimonial and family law, real estate, trust and estates, and elder law. You can watch episodes on YouTube and listen through Apple Podcasts, Spotify, Google Podcasts, Stitcher, and more. For prior episodes, go to www.lawyersonli.com. Now here's the host of Paradigm Shifts, Harriette Steinberg.
Hi, welcome to another episode of Paradigm Shifts. I'm Harriette Steinberg, also known to some as the Divorce Sherpa. I'm an attorney, and I practice in the areas of matrimonial law, trusts and estates, elder law, and estate planning. My process of choice is mediation or collaborative practice when I work with clients. So in each episode of Paradigm Shifts, you will hear from a professional about an important message involving change. We will discuss divorce, aging, death, retirement, and others. And today I am thrilled to introduce Beth Polner Abrahams, a colleague. And good morning, Beth. How are you?
Good morning. Nice to be here.
Yeah. So can you tell us a little bit about you and your practice?
Sure. So I've been practicing for almost 40 years, and the last 25 or so have been in the field of elder law, estate planning, guardianship, special needs planning, and of course, estates. And prior to that, I worked in not-for-profit and for government. So it's been a nice little ride through the areas of law.
So today, my favorite topic is paradigm shifts, right? So
Yeah.
Tell me, what's your paradigm shift? What have you been seeing in your practice?
Sure. So a couple of years ago, I was handling a lot of what we call contested Article 81 proceedings. That is the proceedings to declare someone incapacitated. Families are fighting over who could do it best. And after a particularly difficult case that was pre my knowledge about mediation, we won. We won very sadly. And my client on the steps of the Supreme Court turned to me and said, "I think I just lost my sibling." And unlike myself, I turned to her and I said, "You think you lost your sibling? I could guarantee you lost it." And for me, that was a very important moment. I thought to myself, there has got to be a different way to handle litigation. And so I embarked on the study of mediation, and that was back in 2013. So the paradigm shift for me is when I have a case that might be contested after I sling mud in the papers that get filed, I reach out to my adversary, and I reach out not as a mediator, of course, but with that mediation perspective, that dispute resolution goal. And that has been a huge paradigm shift for me.
So you said a magic word for me, which is the paradigm shift in your goal, particularly when it comes to mediation. Let's talk about that a little more. How would you describe that paradigm shift?
So I think that with the onset of, very wisely, presumptive dispute resolution throughout the New York State court system, it asks a lawyer to think differently about their case, either pre-filing in certain cases or after filing, towards a balanced negotiated resolution. We know that most cases settle, regardless of the nature of the case. So it's a question of how you get there to preserve the integrity of your client, to preserve some of their life. And of course, it requires the lawyer to think differently, to move from, as mediators say, as you well know, from their legal positions to the interests of the parties and the interests of their clients. And I think that that's a really important shift. it's an important shift to recognize. And as more and more lawyers are trained as mediators and more lawyers hear about mediation, perhaps their clients also will start to ask for that opportunity to mediate, to say, isn't there a different way we can handle this?
And from your experience, I would say that in introducing this, if a client comes to you with a contest, some sort of a problem, how do you shift in introducing the concept of a mediation to a client?
So I think it depends on the case. In some cases, the clients are almost saying it. They're saying, I don't have a lot of money to fight this, but it needs to be done, right? So cost is always a part of it. In some cases, the clients are saying, without saying the word mediation, I'm exhausted by this. I've been dealing with this for years, dealing with this conflict in my family. I know I have to go to court, but I'm exhausted, right? So it's asking the lawyer to say it's not an all or nothing scenario. It's not an all or nothing case, because as you know, in a courtroom, there's either a winner or a loser. Although, in my opinion, as mediator, everyone's a loser. And so it asks the lawyer to say, okay, I've laid out my legal position. And while I may have a strong case, which is what they're saying to the client, let's see if there's some way we can recognize. Let's give the other side the benefit of the doubt. And what's their interest? And how does that match up with your interest?
And so when you reach out in that way, do you have a difficulty with attorneys on the other side?
I think that the answer is it depends. Lawyers who have had some success, we've had, mediation has been in the commercial division for a while. Mediation, as you know, has been in the matrimonial part and family court for quite some time. It's newer to estates. It's newer to contested special needs planning issues. So I think that if a lawyer has had an experience with mediation that has been positive for them, positive in result, positive in reaction from their client, positive in terms of, financial, where they can still make money without dragging a case out, I think they're going to be more receptive to an early discussion. I've filed my papers, let's talk.
And so in Article 81 cases, would there ever come a time that, other than the other contestants, would you have involved, for instance, the person who is the subject of the litigation? Do they ever get to participate?
I think that's a really interesting question. I think that it's very fact specific. There are some courts that still in Article 81 guardianship reject the notion of mediation. One reason is that they feel that the individual in and of itself cannot participate. And I'm sure there's circumstances where the individual cannot. They are deeply, deeply in Alzheimer's, or they're in a coma or something like that. But what if they can participate, right? What if their interests can be protected through having counsel appointed for them? And maybe they do have some level of recognition and remembrance. Maybe the visual of them sitting in a room where they're battling children, for example, or sitting, and maybe their brain still connects to the visual of seeing the kids there, and they can express themselves in some way, even though it might be incompletely. So I do think that there's some value to having the incapacitated or the disabled individual present. I think it's going to be on a case-by-case basis, but I don't think it should be ruled out in and of itself.
And, we've had this discussion before. I have often felt that a lot of the Article 81 cases, when the children are involved, particularly, have to do with sibling rivalries, old sibling rivalries that reemerge. Do you see that in your work and what you've been doing?
Oh, absolutely. I think whether it's siblings or, if you have a sudden onset of a disability with divorced parents, they're going to relive that divorce and all the ugliness that went with it. Absolutely.
So essentially, the mediation becomes family mediation 101, I would say, and not only to settle the litigation that is brought to us, but to try to put things back on a better track with families. Would you agree?
I think that that's correct. I mean, I like to tell people, as I'm sure you do, that, I'm not a therapist. I have no training in any of that. Um, but I think that there's a certain way that people can be taught to speak to each other, to have certain protocols on how they speak to each other in a neutral way. We're not asking people to express love or admiration necessarily on an ongoing basis, but there is a way to speak, to engage, to communicate. And I think that's what gets lost and why we end up in contests of that deep family nature often.
So this is the paradigm shift for Beth Abrams, yes?
Yes.
And have you seen any other areas of your work in addition to Article 81? What happens when families come in to you with a drafting question, such as a supplemental needs trust? Do those issues come up as well?
Yes, I think the benefit of training as a mediator is it asks you to think forward, right? To think of other things. So recently, clients came into me and talked about special needs trust for their child after their had passed away, and the people that they were proposing, the siblings that they were proposing to serve as trustees, co-managers of the Special Needs Trust. My question now, which didn't used to be, is tell me how they relate to each other. How do they communicate with each other? How will they communicate about the disabled siblings' needs? I never used to ask that. And I think that's important. We have the same issue when parents just by default say, yes, I want both my children to serve as executors. I used to just say, okay. But now I say, same question. Tell me about how they communicate. How do they, or do they have a habit of resolving problems together? Even if an estate is simple and uncontested, you could have a house to clean out and that's going to dredge up memories. It's going to say, one person doesn't care about the dish towels and another person is going to be, emotionally attached to those dish towels. So I ask different questions than before.
And how are the clients are actually relating to those questions? Are they answering them honestly? And
my clients do. I mean, I think the more that lawyers start to ask that of our clients, the more they realize that, the lawyer is a full service type of person. We're not just using a form, so to speak.
yeah, and frankly, in that vein, I will say we recently had a case where a couple was thinking of estate planning. And they were at the same time dealing with a major problem in the family. You know the case I'm speaking about. And they brought that issue to you. And what was the consequence of that? What happened? Tell us.
So I referred them obviously to you for a mediation variation, almost like a collaborative type mediation to explore the family dynamic because there were so many issues with respect to communication that were affecting their ability to go forward. And from the perspective of estate drafting the documents, it was going to impact how we drafted them. And so I believe that there was a resolution sufficient to allow them to move forward in estate planning because of the process. And I think that raises an important point that you alluded to earlier. The best cases actually may end up in court because someone doesn't have a power of attorney, for example, for financial management. But where there's family strife, the family can take the opportunity pre-filing of a court proceeding to meet with a mediator, to meet with a collaborative team, a family specialist, the mediator, to work out their differences and bring in the lawyers to do that, so that when they actually walk into a courtroom, for example, in an Article 81 proceeding where there must be a finding of incapacity, and it's going to result in an order, they've worked out in advance what's going to happen. And that's actually no different than, after someone dies. The thing that about educating the consumer and hopefully the lawyer about mediation is that you can work this out before you set foot in court.
So really, you've now identified a whole new process for us, which is to start with the concept of mediation, even if it looks like a litigation, and trying to resolve all of the contests, quote unquote, before we get to court. Um, it would seem to me that has to be a better process and a better outcome, right?
I think so. And I think it also asks lawyers to rethink their fees, right? It takes us out of this concept of hourly. I mean, lawyers, as you know, are required to keep track of their time and to disclose certain things, including their hourly rate, et cetera. That's mandated. But how you frame your fees, how you charge so you can make a living, can now take into account this other aspect of your work.
So how are our colleagues receiving this concept, this new paradigm shift, would you say?
I think that's hard to say. I think it's disappointing when I present or you present on this paradigm shift about mediation and the next speaker is just talking about litigation skills, right? It's hard when you're sitting before a panel of judges at a continuing education, and in essence, when asked who would be interested in mediation within their court, where it's a little more optional, like under Article 81, out of 6 or 7 judges, 2 say, yes, I see value. So it's an ongoing educational process.
Well, you know what I say. It's the beginning.
It is.
I'm the optimist, and I truly, and I know you share this with me, Beth, because you've been practicing almost as long as I have, Things do change. We just have to have the stamina pushing the change and the paradigm shift. But I am very optimistic, and particularly with elder law attorneys such as yourself and our other colleagues, I think they're beginning to see the value of.
I would agree. And I think, hey, if out of 6 judges, 2 say I'm interested, that's
Right.
2 more than there were yesterday.
Right. And then we'll just settle the other cases before we go to the other 4 judges. Yes?
Yes.
Yes. So before we close today, I'd like to ask you about a recommendation. Who would you suggest that I speak to next in terms of paradigm shifts? Anyone that you've come across in the work that you do that shares our focus or experience? Some people think paradigm shifts are negative, and I certainly would like to explore their concept or their view. Do you have any recommendations you can give?
I think any attorney that you can find who's had a positive experience as a result of mediation would be great to hear what their positive impact was. I think also the notion of collaborative mediation, which I know you use in terms of matrimonial. I think it definitely has a role in other relationship type cases like Article 81
Yes.
and special needs. So I think a professional in that regard, family specialist, and how they see these issues in terms of mediation would be fabulous.
Yeah, well, just for our audience, the concept of collaborative process really is a multidisciplinary process where we use two mediators, a general mediator that really directs the case, and then a family specialist, sometimes, most of the time, a mental health person who focuses on the issues of communication within the group, within the family. As you know, I have found this extremely successful and rewarding in its use. So with that, I'm going to say thank you, Beth, for our visit. I look forward to more of our collaborative-mediation cases, and we'll talk to you again soon. Thanks so much.
Thank you.
Thank you for listening to Paradigm Shifts, new thinking about our changing times with your host, Harriette M. Steinberg, practicing matrimonial and family law, real estate, trust and estates, and elder law. You can watch episodes on YouTube and listen to Apple Podcasts, Spotify, Google Podcasts, Stitcher, and more. For prior episodes, go to www.lawyersonli.com.